Section 4, or the sphere of application of the Republic Act number 8792. Sphere of application, that means its applicability to certain contracts. This act shall apply to any kind of data message and electronic document used in the context of commercial and non-commercial activities. Recognizes electronic signature as equivalent to signatures on a written document. What is an electronic signature? An electronic signature is an electronic sound, symbol, or process attached to or logically associated with a contract or other record and executed or adopted by a person with the intent to sign the record. For example, for a hospital department, reducing the time it takes to get signatures from doctors, patients, and insurers is vital. In one radiology department, the time needed to get signatures for abdominal examination drops from 11 to 3 days. The time needed for signatures related to chest examinations dropped from 10 to 5 days. By using e-signatures, it shortens or skips steps in employees' workflows and rose productivity. Let's now proceed to the next slide. Section 8, or the legal recognition of electronic signatures. E-signature is equals to written signature if a method is used to identify the party sought to be bound and to indicate said party's access to the electronic document necessary for his consent or approval through the electronic signature. If both parties has to do something or has access or had consent or approve it through e-signature, method is reliable and appropriate for the purpose for which the electronic document was generated or communicated in the light of all the circumstances, including any relevant agreement. For example, if you sign and agree to the lender that if you can't pay for the promised date indicated in the contract, you might get into prison because you signed it, it means you agreed to that condition. Next, it is necessary for the party sought to be bound in order to proceed further with the transaction to have executed or provided the electronic signature. For example, if the family of the dead person doesn't sign the paper to conduct an autopsy to the body, they cannot proceed to the next step. Next, the other party is authorized and enabled to verify the electronic signature and to make the decision to proceed with the transaction authenticated by the same. For example, in the bank, when someone wants to withdraw but he's far, so he sends someone to withdraw by writing authorization letter. The accountant will be responsible to check if the signature is authentic in order to proceed to the next transaction. The next section is the section 30, or the extent of liability of a service provider. So what is a service provider? We're talking about the provider of online services or network access, or the operator of facilities. Guidelines as to when a service provider can be liable. The obligations and liabilities of the parties under the electronic data message or electronic document. The obligations or the liabilities that was included on the contract of the service provider when he signs it. The making, publication, dissemination, or distribution of such material or any statement made in such material, including possible infringement of any right subsisting in or in relation to such material, provided that the service provider does not have actual knowledge or is not aware of the facts of the unlawful act. For example, a terrorist purchases a cell phone from your shop and uses it to make a bomb and kills 1,000 people. The service provider doesn't have obligations on that because he is not aware that his customer is a terrorist unless he's a mind reader. The service provider does not knowingly receive a financial benefit from infringing activity. Based on my understanding on this, the service provider receive money, but he doesn't know that it comes from unlawful act. The service provider does not directly commit any infringement or other unlawful act if that nothing in this section shall affect any obligation founded in contract. An obligation under contract can only be enforced if the party who wants to enforce the obligation has given up or promised something in return. When the said circumstances or liabilities doesn't found on the contract which the service provider signed, the service provider doesn't commit any unlawful act. The obligation of a service provider as such under a licensing or other regulatory regime established under written law. Based on my own understanding, it is the obligation written on paper or manual that is signed by the service provider. Any obligation imposed under any written law. Definitions of obligations in the original sense. The idea of obligation referred to only the responsibility to pay any money outlined in the terms of specific written documents. The civil liability of any party to that the service provider take or refrain from actions necessary to remove, block, or deny access to any material or to preserve evidence of a violation of law. So when the said party destroy any evidence as accidentally or not, there is still a punishment.